Good afternoon, Section Z. We're in our series of review lectures looking at material from earlier in the semester, and I received a request to go over the doctrine of destructibility of contingent remainders and illustrate how things are different now that it has changed or now that it's been abolished in most or all jurisdictions. So let's pull up the Duke Miner textbook that talks about destructibility doctrine. We're over on page 208, and here is the destructibility doctrine in a nutshell. A legal remainder in land is destroyed if it does not vest at or before the termination of the preceding freehold estate. And so they give us an illustration here in example 15. O conveys Blackacre to A for life, then to B and her heirs if B reaches 21. So what interests are created? Well, O has conveyed a life estate to A. O has also conveyed a remainder to B in fee simple. How do we know it is a remainder? Well, first of all, it's in a transferee B, and so it has to be either a remainder or an executory interest. And a remainder is a future interest in a transferee that is possible of becoming possessory upon the termination of the preceding freehold estate. So here, the life estate in A, when that ends, is it possible that B would be ready to take possession? Well, yes, B could already be 21. B could take possession immediately upon the end of A's life estate. So since it's possible for B's interest to become possessory upon the termination of A's life estate, it's a remainder rather than an executory interest. It would be an executory interest if it had to cut short some vested interest, but that's not necessary on these facts. And so it's a remainder interest. Now, is it contingent or is it vested? Remember, two rules for vesting of remainders. One is whether it's to an ascertained person. Here, we've ascertained the taker, it's B. But then the second is whether there is a condition precedent other than natural termination of the preceding estate that has to be satisfied for the interest to vest. And here, B has to reach the age of 21 and is not there yet. And so because of that condition precedent, the future interest in B is a contingent remainder rather than an executory interest and rather than a vested remainder. Now, notice there's one other future interest created by O's conveyance that we haven't mentioned yet, and that comes from applying Professor Syme's formula to identify the existence of a reversion. So Professor Syme says a reversion is an interest that exists when a grantor conveys a vested estate of a lesser quantum than the vested estate that the grantor had. And so here, O had a fee simple estate. He has conveyed a vested life estate to A, but the fee simple estate that he conveyed to B is not vested, it's contingent. And so the vested life estate that he conveyed is an estate of a lesser quantum than the vested fee simple estate that he had. And so O has retained a reversion in this hypothetical. And therefore, if we apply the doctrine of destructibility, if A dies and B has not yet satisfied the condition precedent of reaching 21, the doctrine of destructibility would destroy B's contingent remainder, and O would have right of possession by virtue of the reversion. Now, over on page 209, they talk about a related doctrine, the doctrine of merger, which says that if the life estate and the next vested estate in fee simple come into the hands of one person, the lesser estate is merged into the larger. And they note that because of that rule of merger, that when you have it combined with the destructibility doctrine at common law, it was possible for the life tenant to essentially destroy a contingent remainder by making sure the life estate and the reversionary interest came into the same set of hands. If the contingent remainder was contingent at that point, then the doctrine of merger would merge the life estate and the reversion and would eliminate the contingent remainder. Now, down further on page 209, they tell us that the doctrine of destructibility of contingent remainders is, for the most part, no longer applicable. They say that the new restatement does not recognize the destructibility rule and states that it has been abolished by statute or case law in nearly all states. So let's pull up a problem from a prior version of the textbook and think about how to apply the destructibility doctrine in light of this problem, and then think about what would happen if the destructibility doctrine no longer exists in this jurisdiction. So we're told that T dies, leaving a will that devises Blackacre to A for life, then in fee simple to B's children who survive B. So the first question we've got to answer is, well, what interests are created by T's will? Well, first of all, A has a present possessory life estate in Blackacre. And then we have language creating a future interest in B's children who survive B. That future interest will be in fee simple. And so we've got to figure out what kind of future interest that is. Well, that is an interest in a transferee, B's children, rather than in the transferor T, or T's estate. And so, since it's in a transferee, it has to be either a remainder or an executory interest. So is it possible for this future interest to become possessory upon the natural termination of A's life estate? Yes, it is possible. You could have, you could know all of B's children who survive B. B could have passed away before A, and the people entitled to that, holding that remainder, could have a right to possession immediately upon A's death. So since it's possible they could take possession when A's life estate terminates, it is a remainder rather than an executory interest, does not have to cut short a vested estate to become possessory. Now, is it a contingent remainder or a vested remainder? And this one is a class gift. It's in B's children who survive B. We had two rules for vesting. Have we ascertained the takers, and is there a condition precedent? Even if we know some of B's children, we may not have ascertained all members of the class. B is still alive, and so presumably can still have children. So it's possible that there could be more children who would be born to B. But the bigger problem for vesting is that there is this condition precedent. We only give the remainder to B's children who survive B. And so the condition precedent of surviving B makes this a contingent remainder rather than a vested remainder. Is there another future interest? Well, T had a vested fee simple estate in Blackacre and transferred a vested life estate in Blackacre, and then a contingent fee simple in B's children who survive B. But if we apply Professor Syme's formula, then we find out that T has a reversion, or technically, since T is dead, I guess T's successors, T's estate has a reversion in Blackacre, because the vested estate that T had, fee simple, was of a higher quantum than the vested estate that he gave, the life estate. And so since A's vested estate is of a lesser quantum than T's fee simple estate, then T has retained a reversion in this devise. So what happens under the destructibility doctrine if A dies during B's lifetime? Well, notice that if A dies and B is still alive, then the future interest in B's children who survive B has not yet vested, because we cannot identify which of B's children will satisfy the condition precedent of surviving B. B's still alive, we don't know which ones will outlive B. And so if we apply the doctrine of destructibility upon A's death, since B's children are not ready to take the estate, since it's not vested, the contingent remainder in B's children who survive B is destroyed, and the land reverts to T, or T's estate here. Now, we're told, though, that the doctrine of destructibility has been abolished in most or all jurisdictions in this country. And so what happens if we don't apply the doctrine of destructibility of contingent remainders? Well, now, when A dies and B is still alive, the contingent remainder is still contingent. The holders of the contingent remainder have not yet received a vested interest that would allow them to take possession, because there's still this condition precedent that they've got to find out which of B's children survive B before they know which ones are entitled to Blackacre. And so they're not able to take possession when A dies. So what happens? Well, then the land will revert to T, because that's the next vested estate. And so T's successors, T's heirs or devisees, presumably would take the land at A's death. But that doesn't mean the future interest in B's children who survive B is destroyed. Instead, since we no longer have the Destructibility Doctrine, it converts into an executory interest. It's now an executory interest rather than a remainder, because in order to become possessory, this interest in B's children who survive B is going to have to divest the vested remainder in T's heirs or devisees. And so basically, it's no longer a contingent remainder upon A's death. It's now an executory interest upon A's death. That takes you through the doctrine of destructibility and gives you an idea of why it matters and how it applies.